Well, let's move on to the other big story, and a story that we here at Mirror Now have been tracking very, very closely. Now, while this is the news aspect, the conversation and the debate I want to have today is about a larger problem. The news aspect is the fact that stand-up comic Munawar Faruqui has now been granted interim bail by the Supreme Court. He's been in jail for about 35 days. He was arrested on 1st of January. His bail was rejected by the lower court. His bail was then rejected by the High Court. And then he finally landed up at the Supreme Court, where the Supreme Court today has given him interim bail, issued a notice to the Madhya Pradesh government, and also put a stay on the production warrant that was issued by the UP's administration. Now remember, UP police are actually already lined up that whenever Munawar gets out of jail and gets bail in Madhya Pradesh, we will arrest him because we are also offended by the same jokes. But the Supreme Court has now put a hold on those production warrants. Why? Because the Supreme Court says and has to remind the Madhya Pradesh police, did you follow the procedure that has been laid out as per the 2014 Supreme Court order? The Supreme Court asked, is it correct that the Anish Kumar judgment rules have not been followed? If not, then that's enough. Now, this brings us to the conversation point. The order itself of 2014 by the Supreme Court. And at that point, the Supreme Court has said that the arrest brings humiliation, it curtails freedom, and it casts scars forever on an individual. That the police must ensure that they do not arrest an accused unnecessarily. That they must ensure that the magistrate does not authorize detention casually and mechanically. That every police officer shall forward a checklist. Every police officer shall have a checklist for the arrest that has to be duly filled up, where you have to explain your reasons for this arrest, give materials to validate and back your arguments, why this arrest is necessary, and then produce him before the magistrate. So do you really think that this gets followed everywhere in our country? Well, a case in point is Munawar Farooqi's case, which is why today he's been given bail on those grounds. But let's talk about our overzealous law and order machinery and overzealous cops, perhaps often with the intent of impressing their political masters, but resorting to arrest in any case. Not serious grave crimes. I am not referring to the gravest of the crimes, the most serious crimes involving brutal murders or terror attacks and all those. I'm talking about somebody who cracked a joke and perhaps ended up offending someone's sensibility, or didn't even crack a joke, intended to crack a joke and ended up offending somebody's sensibility. Is there a concern about the arbitrary arrest in our country? Is there a concern that more and more instances are now cropping up where jail and not bail has become the norm versus the other way around? That's the question I want to ask our panelists this evening. So let's say good evening to Desh Ratan Nigam, advocate of the Supreme Court, Mr. Aryama Sundaram, senior advocate, also joining us of the Supreme Court, Mr. Arvind Kumar Jain, former DGP of Uttar Pradesh, and Nalin Mehta, Dean for the School of Modern India, UPS, and senior journalist joining us this evening. Mr. Aryama Sundaram, good evening to you. I'll come first to you. This is an example that I wanted to take to ask this larger question. Now, a 2014 order that almost everybody knows about, does it get followed that often? And why was it necessary even for the Supreme Court at that time to really put it in words to say this should be the process followed?
Tanvi, let me answer your second question first. You see, that bail is the rule and jail is an exception is a well-known legal maxim. When I studied law, it was taken as a given, that bail was always granted and jail was something which was only resorted to in extreme circumstances. Equally, the question of arrest, very often pre-arrest bail, what we call anticipatory bail, was granted Because again, for the same reason that bail would be the rule and jail an exception, unless the court found it was a serious enough crime, a heinous enough crime to warrant custodial interrogation or incarceration of the person. Now, all that Arnesh Kumar really did was to put finding that it was this basic first principle of law was not being followed, and there was an arbitrariness in the manner of arrest by the police, where people who ought to be arrested were not being arrested, people who ought not to be arrested were being arrested, and therefore also giving rise to feelings of corruption in the police. Seeing that this first principle of law was not being followed, Arnesh Kumar basically brought into place guidelines. Now, these guidelines the court often resorts to when it finds that the state machinery, that the executive itself has left a big gap and are acting arbitrarily. And whereas the law is well known, in the implementation of the law, there's a lot of arbitrariness. Therefore, guidelines come to be framed by the Supreme Court, by the higher courts, in order to see that the actual execution of the law is done in accordance with well-known principles, correct principles, judicial justice principles, with keeping justice in mind. That was the purpose of Arnesh Kumar. It really laid down guidelines to ensure that the law and legal principles was properly maintained. The fact that they're not being followed is just an example of the arbitrariness which the executive seems to exercise at some time through the police, where people, like I said, who ought to be arrested are not, people who are not to be arrested are, and therefore these guidelines and their following becomes imperative. I think when we discussed this topic the other day after the Madhya Pradesh judgment, I had voiced my entire concerns and disagreement, my complete disagreement with the Madhya Pradesh judgment. And I think today what the Supreme Court has seen is there are certain lacunae in the Madhya Pradesh judgment which required not only issuing of notice, but an actual grant of interim bail at the very first hearing. And I'm very glad that has been done, because I think this was a very typical case where the machinery of arrest has been misused. It's a very typical case of that, and where Arnesh Kumar's principles have been thrown to the wind despite the guidelines having been laid down.
Yes, in fact, let me take this point across to Mr. Jain. And Mr. Jain, would you agree that there are, not just now, but even earlier, enough and more examples? Is it because, the policemen aren't sensitized enough to the fact that, well, arrest is not really necessarily a first option, and that shouldn't be the norm unless it is absolutely necessary? Is there enough awareness and understanding about this fact?
Yes, there is awareness. I won't deny it that there is no awareness. But at times when such incidents take place, when Hindu gods and goddesses, they are insulted or something is said about them. So one should realize that there is a BJP government in MP, there is BJP government in UP. If he had said this at Kerala or West Bengal, I don't think there would have been any action. But one should realize that one is speaking such scurrilous things against filthy things. I am told, I have not read the content, but against Hindu gods and goddesses. So some son of some MLA, BJP MLA, he has filed FIR. FIR is said to be vague. FIR is said to be not following the procedure. Section 40, which is laid down in Section 41. That's why he has been given interim bail. But the case the trial will go on. Trial will go on, and I think it is high time that one should not make fun of Hindu gods and goddesses. Hindus are not expected to say something against Prophet Muhammad or Mother Mary or someone. It is not done at all. Sensibilities of the other religion should also be respected, and such jokes are absolutely uncalled for, and they create enmity in the society.
Mr. Jain, I disagree with you. I don't know why jokes are creating enmity in any society. Jokes are meant to create laughter and joy in a society. And believe me, enough number of Christians and crack jokes on their own gods and goddesses, and even on Jesus Christ or on the Pope. They don't really need Hindus to come and do it for them. These guys crack jokes on their own. This guy that we are talking talking about right now. Yes.
Tanvi,
I am. Let
Tanvi,
me just finish my point. Allow me to finish this point. Munawar Farooqi cracks jokes across religions, across political parties. And in this case, if I can add to the point, because you very rightly said you don't know what he said, nobody knows because he didn't say it. In the case of the Madhya Pradesh story, it's about somebody claiming they overheard him rehearsing certain jokes that he was going to crack at the gig. But he didn't. There is no recorded evidence, electronic evidence yet available that at that place this would have happened. Now, if they found jokes from 4 years ago and got offended, then it is even more ridiculous that 4 years later they've gotten offended about some joke and now they want him inside jail. Nalin, you wanted to come in and make a point?
Yeah, I want to make 2 points here. The first is that, sir, nobody is going to defend if somebody makes offensive statements on X, Y, or Z. But that's precisely the point here, that that is what the courts will adjudicate. The issue is not so much what happened or didn't happen. In this case, there is enough doubt on the matter in terms on the ground, whether he said it or not for a joke that he might have cracked or may have thought of cracking in the future. The point is, as Aryama Sundaram pointed out, the question is that there are very clear procedures laid in law. That's the job of the courts to adjudicate. What happens is who's going to judge? I mean, I can say something. I mean, do we want to turn into Pakistan, where purely on the suspicion that somebody may say something which may be inimical to your religion, you will be put in jail and you are guilty until proven innocent, or you will not get bail until you are proven innocent? That actually reverses the entire notion of natural justice. And there are legal precedents in place for this. In this case, the Supreme Court has specifically laid out that, as Aryama Sundaram also pointed out, the 2014 principle of 2014 judgment were not followed. The question I want to ask is, who is going to be held accountable for that? I'm not talking at all about making a judgment at all about Munawar, what Mr. Farooqi may or may not have said, or what he could have been thought to have said, or could have been thought to have imagined. The point I'm making is, when on the basis of mere suspicion, if police officials start filing FIRs and then somebody's put in jail and lower courts do not follow the set principles of jurisprudence, who's going to be held accountable for it? That is the end of any rule of law, because then anybody and everybody can be under suspicion. Tomorrow somebody could put a suspicion on you, sir, or on me for something that we may or may not have said, and then we are in jail. I mean, this guy has been in jail. I'm not prejudicing whether what he said or not. He's been in jail for more than 30 days on a principle in which the Supreme Court has said that the procedures were not followed. It's even set aside the procedural FIR. So my question really is, when are we going to have accountability for police officers and even for the judges, with all due respect, who did not follow the prescribed procedure set by the Supreme Court?
Okay, thanks Nalin for that. Let's break this down into two aspects of your question. So, Mr. Jain, before I go to Deshratan, to you this question, if the procedure is not followed, laid down by the Supreme Court on how to go about making arrests in this case, or on the checklist that has to be maintained, on the material that you must furnish before the district magistrate in such cases, if that doesn't happen, who is going to hold those policemen accountable? Because this clearly looks like a case where they came under political pressure and did what they thought was the best thing to do at such times.
You are absolutely correct. I agree with other panelists. Once the judgment reaches the state of Madhya Pradesh and concerning authorities, a preliminary inquiry will be ordered as to why there were procedural lapses. But one should not forget that bail was even denied by Madhya Pradesh High Court. They will not deny bail unless and until material has been put before the bench. How can they deny the bail? And I am happy that Supreme Court has overturned the judgment and has released him on bail. But you know what happened in Paris over a cartoon? So one should take into consideration the sensibilities of other people also, and one should desist, avoid making such comment. There are other topics also on which you can be comical. You can say so many things. I don't think I have read about this man Faruqi. He has not said even a single word against Islam.
No,
So
you're
why-
wrong. It's not about whether he said a single word against any religion, because effectively, Mr. Jain, he is only still cracking jokes which are not meant to be serious, but he's cracked jokes on multiple religions. I mean, if that's how you see it, but it's basically to find humor in tricky situations. He links it to his own experiences, including what is otherwise the contentious and controversial, touchy, sensitive subject of the 2002 riots. And he links his experiences and finds humor in them and presents them. I would urge you, instead of reading what many may be writing, to just watch some of his content. And again, I would say that if you don't find it funny, that's all right. I don't think we should become a society, that's my personal view, where we start taking offense. In the room where he was going to perform, and when he started the performance and this halla started and these BJP guys came in and started, objecting to it, not a single person who was there out of choice to listen to him and had paid money for the show actually wanted Munawar to stop. They were all backing him and saying, you don't even need to explain it to this guy. But there were others who thought this was a problem and they created trouble. Let's get back to the legal aspects of it. And to the second aspect that Nalin and I were talking about, Mr. Deshratan Nigam, the fact that yes, the Supreme Court today asked this question, if you followed the procedure and if you followed what was said by Supreme Court in 2014, but that's something that seems to have been missed in the earlier bail hearings. Now, is that a concern as well? Do we have to wait to get to the Supreme Court every time?
Tanvi, that's how our legal system works. You go to the trial court, then you come to the High Court, and then you go to the Supreme Court. And therefore, let us be very clear, that's the process laid down. I agree with Mr. Sundaram about the legal position that has been enumerated by him in this, and he was very clear and succinct about it. But the fact remains, if anybody goes into the petition of Munawar Faruqui, where he admits that he has cracked the jokes, and he says, but it was merely a satire for the purposes of entertainment, and the entire comic was never meant to be taken seriously. So he personally decides that others should not take it seriously, and he has admitted to cracking those jokes on Hindu gods and everything. However, it will not be on his subjective opinion, but by the court whether he has come within the domain of section 295A, which has been imposed on him, or 153A or 124A. And therefore, that's a larger question of trial, and that has to be established. But can he ever make a satire on Prophet Muhammad's marriage to a 9-year-old girl and then say it was only for the purposes of satire or not to be taken seriously? Can he ever do that? Kamlesh Tiwari did, and he was beheaded. Please remember
Mr.
that.
Nigam, I've heard, we've had this conversation ad nauseum. Please, let's stick to the conversation point tonight. We can't keep getting derailed with the same arguments again and again, Mr. Nigam. I really request you.
This is the larger issue, Tanvi.
No, this is not the larger issue tonight, Mr. Nigam.
Yes,
the larger issue I'm asking is the problem of overzealous cops in our country who, in their zeal to impress their political masters, keep arresting people and putting them behind bars, and everybody has to then go to the Supreme Court to get some relief. That is the larger issue, Mr. Nigam.
I am entitled for my opinion, and please give me a patient hearing.
That is the theme of my conversation and my debate tonight, Mr. Nigam. It is not why people in this country are not cracking jokes on Muhammad.
Linking the two. You are not allowing me to link the two. I am linking the two issues. He has admitted in his petition that he has done so, and he is becoming a judge in his own cause, that it should only be taken for satirical purposes.
Yes, that is what comedy is meant to be. He is not writing a serious thesis. That's exactly what I am also saying. But I don't want to debate that tonight. I am not debating the merits of his case with you tonight, Mr. Nigam. I am simply debating the norm for arrest versus bail right now. That's all.
Yes, every case now stands on a different footing. Even Arnesh Kumar case would stand on a different footing. Guidelines have been laid down, no doubt. And now, once you start comparing Arnab Goswami's case with this case, then one has to see what kind of a case is this. Therefore, though this is a case which stands on a different footing, which has a larger connotation for the society, where riots can take place because of this, the society's harmony and peace can be disturbed. This is a very serious case,
I
and the
have,
courts have to be looked into it. And
okay.
what the High Court said, please remember, High Court made some very serious, comments and said and looked into the material available on record, and therefore notice has been issued to the Madhya Pradesh government, who will come and make their statement and on affidavit before Supreme Court. And therefore, this is an ad interim bail, not a final or regular bail. It can be cancelled. Please remember that it can be cancelled on the next date or whenever the High Court. I'm not sure. I don't know what Supreme Court would do. The Madhya Pradesh government's stand still has to come before the Supreme Court, and for that purpose, notice has been issued. They have to be heard finally, so that a final view can be made by the Supreme Court. This is a prima facie view, not the final view of the Supreme Court.
All right. Mr. Sundaram wanted to make a point.
What I wanted to point out was, I did hear reference to Section 295A, etc., and that there was an admission that certain statements had been made as a satire, as an aim towards comedy, and therefore it was an admission of an offense. I just want to clarify that the offense is somebody who, with an intent to incite hatred or communal disharmony, says or does something, which is really the antithesis of someone who says, I did so for a purpose of satire. The very fact he said so for satire, if true, and if it is shown that was his only intention, would bring him clearly out of Section 295A, because the intention is not to cause religious hatred or communal disharmony. Having said that, the point I want to highlight is, today what we're really discussing is, the trial will go on, the crime will go on. Should the man have been in jail for 34 days for something like this or not? And that is where I feel that offenses like this, putting a person in jail, when usually you would grant bail unless the person is going to escape justice or or he's committed a heinous crime and he's a danger to society, or he's going to tamper with witnesses. As was said earlier, he himself has said that he made the statement, or he's going to tamper with evidence. These are reasons to refuse bail. Unfortunately, we're getting to a stage where we're getting too prickly and refusing bail only because we immediately feel there's an affront against some religious sentiment, and therefore bail should be refused. I believe that the yardstick for whether bail should be granted or not granted doesn't change. The yardstick remains the same when it is a crime under the IPC. You give bail or refuse bail in certain circumstances. And in my view, none of the circumstances for refusal of bail had arisen in this case. So even if an offense was to be registered against him, even if he was to have been arrested, he should have been granted bail straight away, because he didn't come in the category of people who should not be granted bail, which takes us back to the first principle, that bail is the rule and jail the exception, and not the other way around. And the law does not change merely because it becomes something which came under 295A rather than under Section 407 or 420 or something else. And that's the point I want to make.
Can I add something?
Yes, okay. Nalin, I'm coming to you next. Let just Deshratan Nigam respond to this, and I'll come to you. Yeah.
No, so far as intention is concerned, merely his statement cannot be taken as final word, whatever he admitted in his petition. That would be seen after the trial on the material available on record. Therefore, at this stage, it cannot be taken as a gospel truth, whatever Munawar has said in his petition. So that is, to Mr. Sundaram, that intention can be seen after only trial and various material available on record. That's the principles of trial, I believe. And secondly, let me tell you, if this man has been doing this since a very long time and is a habitual person who's been attacking the Hindu gods and other things, and therefore there is a clear possibility that he may again do it coming back, and again there is a distinct possibility that he may disturb the peace and harmony.
May I just tell you that, Mr. Nigam, if you are entitled to your view, you may be right, he may have been cracking these kind of jokes for a really long time, but I just want to add to that, I think it's quite possible in our country that when politicians make fiery communal speeches for the want of votes, and very soon you will be seeing a lot of that. It's quite possible, and it does happen repeatedly in our country, that we see communal clashes. We see law and order issues and we see violence unfold. Hardly ever do we see any of those politicians go into jails. They instead end up becoming elected people in our country. Now,
Election Commission does take note of that.
Yes, Election Commission does send notice, and once in a while they do manage to even suspend you from campaigning in the last period. But nobody lands up in jail for 35 days. Mr. Nigam, let's be serious about that. Riots have happened in those cases. I am yet to see a case here in our country, Mr. Nigam. If allow me to finish my point, I am yet to see a case in our country, Mr. Nigam, where riots, brutal, deadly riots, bloody riots have happened over a joke. So can we please stop saying that this will lead to a riot-like situation? I can give you at least 100 examples where fiery political speeches have led to riots and have led to deaths in our country and bloodshed in our country. That's where the seriousness of the case comes. People who should be in jail and are not in jail. This is yes, 10 seconds.
Give me 10 seconds. Yeah. You know, you can't justify Munawar's conduct on the basis of...
I am not justifying Munawar's conduct at all. That's for the courts to decide. No. I am simply telling you.
Finish. You did not even give me 10 seconds. Let me finish. See, that's a very difficult way to argue in a debate, you know, when every 10 seconds I am being interrupted. So let me give you an example out here. I clearly say those who incite people during rallies or politicians, they should be behind bars. So one wrong cannot justify Munawar's wrong. That is where you are leading to. Please remember,
no, I am not.
Wrong, does not mean Munawar should also do wrong.
I am not. I think we've all agreed that as far as this guy's case is concerned, that's for the courts to decide. But I am just pointing out the great travesty of our country where riots actually do happen because of political speeches. Nothing does take place. No action happens. But we keep saying because of joke there will be a riot. I am yet to see one. Nalin has been wanting to make a point. Yes, go ahead, Nalin.
Tanvi, I just want to make a very simple point to respond to Mr. Nigam, which is the argument that Mr. Nigam himself started with in his previous statement, which was that you cannot take the statement of Munawar Farooqi, I think he said, if I can paraphrase him, as gospel truth. That's for the court to decide. You can make exactly the same argument for the opposite view, that you cannot take the statement of the accusing party as gospel truth. We are not here to adjudicate on whether Munawar Farooqi was right or wrong, and we're not even and in fact there's an argument about satire which you made. I'm not even going there. I'm simply saying at a very basic level that if courts do not on the principle of bail, on the principle of something, nobody here is going to condone hate speech or things that could lead to riots. All I'm saying is that when somebody is accused on the basis of suspicion, on the basis of a perception, that is for courts to adjudicate. You cannot lock up someone on the basis of suspicion, because then you're holding virtually every citizen is going to be hostage to that fear basis of which political party is in power and who are you likely seen to be supporting of. That is a game that every party can play, and it really is a matter of individual freedoms and the rule of law in a democracy. Again, I am not saying anything about the case of Munawar Farooqi in particular as well. I'm talking about the principle over here of jurisprudence and of reason that you are innocent until you are proven guilty in a court of law. And if you are not talking about very heinous crimes and so on. So, and I think there are legal minds here who know the law much better than I do, and therefore I'm talking purely on the principle of that. And I think they should really know it. They should really. It doesn't. I mean, it's the basis of our individual freedoms.
So I have a follow-up to that, and Mr. Sundaram, if you can answer. Again, while yes, bail and not jail should be the norm, while we do say that you have to look at the situation and say whether this warrants somebody being in custody or whether there will be tampering of evidence, whether he will run away, those are the simpler ones to decide. But when it comes to the seriousness of crime, then are there guidelines to when there should be bail or jail?
Oh, yes, of course there are. For example, if it's a serious heinous crime, for example, if it's a rape, if it's a question of murder, in these kind of crimes, the bail becomes slightly more difficult, not slightly, very much more difficult for more than one reason. The first reason, obviously, is that a person who's capable of committing physical harm to somebody else is equally capable of threatening witnesses. He's equally capable of threatening and putting in fear the family of the people who are accusing him. Take a case of rape. We've seen enough cases like this where they come out of jail on bail and then threaten the family, threaten the girl, and make them recant their case. Now, there are also cases where you're facing something like life imprisonment. Your temptation to try to run away from the law and make yourself far from the arms of justice are very common. The temptations are very strong. Equally, you could be a menace to society. A person who's, for example, a person who's a murderer, who's prone to violence, a person who's a rapist, who's prone to heinous crimes like this, is more a menace to society. So the yardsticks become different in the cases that are. But the point is, the basic principles are the same. The basic principles are the danger to society in letting the person out of jail, the intimidation of witnesses, the escape from justice. The basic principles are the same. But based on the crime, the likelihood of those would change. And that's the point.
All right. On that note, I'm going to thank all of our panelists for joining us and, sharing their views on this conversation. The larger point that we wanted to make here, viewers, is that not in every case should the immediate response be jail this person. And this has been repeatedly said by the courts of our country. This has been repeatedly said in multiple orders that have come out from Supreme Court, that personal liberty must also be kept in mind. It's not just about social order, and that right to personal liberty is a right given to us as per our constitution. So one has to be extremely careful, and the police needs to justify when they pick somebody up and put them behind bars as to why they are doing it. Unfortunately, this doesn't always get followed, as was the case here. And while, yes, in our country, you have a lot of options to seek justice, one court after the another, right up to the Supreme Court. For any Indian, you have access. Sometimes it just takes time. In this case, 35 days before Munawar Farooqi is able to walk out of a jail for a joke that he didn't crack or almost did crack. Think about that. Thank you so much for joining us.